Hey all, in this video I'm going to be answering the question, can you be fired for attending a political protest? And like most legal questions, the answer to this is not straightforward, so we're going to have to do a little bit of work to get there. Now, generally, whether you can be fired for attending a protest is going to depend on two things. First, do you work for the government or a private company? And second, if you work for a private company, what state are you in? So I'm going to talk about government employees first because that's the most straightforward, and then I'm going to talk about private employees with a focus on California. Political activism by government employees is protected by the First Amendment right to free speech. Now, I find that the First Amendment right to free speech is one of the most misunderstood legal concepts. The First Amendment says that Congress shall make no law abridging the freedom of speech. Okay, the key word there is Congress. And for a reason I won't get into, this applies to state and local governments as well. So what the First Amendment says is that the government cannot limit your freedom of speech. This does not prohibit a private company, say for example Twitter or Facebook, from censoring you. Now, if you're a public employee, the government is your employer, so the First Amendment applies. However, no right is absolute. There are always limits. And the rule is that the government can terminate you, can discipline you for your political activity if the government's legitimate administrative interests outweigh your freedom of speech. Okay, this is a balancing test, and it basically comes down to how much is your political speech, your political activity disrupting the government's ability to do its job. For example, say a public school teacher attends some far-right political rally and holds up a sign that says, "Deport all illegal immigrants and Muslims." And someone takes a picture, it spreads on social media, and a local controversy just erupts around this teacher. And say that teacher has several undocumented students, several Muslim students, and those students are afraid, and their parents start keeping those students at home because they're so concerned that the teacher might call ICE or otherwise put the students in danger. Well, the purpose of a school is to educate students, and doing so requires that the school create a safe and supportive environment. And the role of a teacher is to develop a positive relationship with students, to nurture them, to help them achieve their educational goals. And so in this case, the government has a pretty good argument that terminating the teacher is warranted because the teacher is creating such a severe disruption to the government's mission of providing public education to the community. Now that's an extreme example to make the point, right? Normally going to a political protest or being engaged in political activity is not going to create such a significant disruption of the workplace. The First Amendment very strongly protects free speech, as it should, and government employees absolutely enjoy that protection. So that's government employees. Let's move on to talk about employees of private companies. As I explained, the First Amendment does not cover employees of private companies. So the question then is there an applicable federal or state law? Now, there is no federal law that just generally prohibits employers from terminating workers based on their political activity. Federal law does, however, prohibit employers from terminating employees based on protected categories like race, sex, religion, disability, and so on. So one question is the employee's political activity intimately connected to a protected category that they belong to? For example, say you're African American, you attend a Black Lives Matter protest, and your boss fires you because he doesn't like that. But you've got several white coworkers, and several of those coworkers are involved in political activity, and one of those white coworkers even went to a Republican Party rally a couple weeks ago, but nothing happened to him. Well, in that case, it starts to look a lot like race discrimination because the employer is disciplining employees based on their political activity in a way that is racially discriminatory. But again, there's no general nationwide federal law that generally prohibits employers from terminating employees based on their political activity. So if there's no federal protection, the question then is there an applicable state law? And for many states, the answer is no, employees are not protected. But for many states, thankfully, the answer is yes. These states include California, Colorado, Louisiana, Nevada, Nebraska, and several others. Now, I can't go into the details for all of these state laws. Of course, they vary state by state, but I do want to talk a bit about California. California law is very good on this. Generally speaking, an employer cannot terminate you based on your political activity. Two caveats. You can be fired if you miss work without permission to protest. That's kind of obvious. And secondly, you can be fired if your political activity causes a significant disruption to the employer's business. This is similar to the First Amendment standard that we went over, but like the First Amendment, it's a very high bar for the employer to get over to justify terminating you. Now, if your boss unlawfully terminates you for your political activity, they're guilty of a misdemeanor and they can be fined. You can also sue the employer for damages, which is just a fancy word for money. This includes back pay, the amount of wages that you've lost, and it also includes front pay, which is the amount of wages you would have earned up until the point where you can find another job. Now, what if you're arrested at a protest? In California, your employer can ask you about the arrest, but they cannot terminate you simply because you were arrested. And this is because of the presumption of innocence. If you're arrested, you're presumed to be innocent of the crime until either you plead guilty or you're convicted of the crime at trial. So if you're arrested, but your trial is still pending, you're presumed to be innocent, and your employer cannot punish you by terminating you for the arrest. If you're ultimately convicted of the crime, then the employer has more leeway to consider whether that particular conviction disqualifies you for the particular position that you hold with the company. All right, well, I hope that was helpful. Good luck to you all out there.